I think two things, a bit of research on your part. One is to see lo that fal case the mines case here. You look in lot other minerals where you could be owned by private individuals. What now the law himself or that one, if they own the land, did they own the minerals? Only gold and silver no more.
Yes, so that was the position at that time.
And if so, this question of surface.
Yes, so the common law also accept this surface agreement because since you have the crown owning these minerals, but to get to the minerals you need to first come with to deal with those.
That's if
owners.
someone else was the investor.
Yes, someone else.
But if you were digging your own land, you won't need surface access. You have
Yeah. But then, as we know, mines it's highly regulatory. Like the provisions that we have in our laws now, it's a stem out from what's been there many years
But the
ago.
other side to that bit of work, which would be useful to us, is to see in the modern era whether there are jurisdictions, common law jurisdictions in particular, but maybe other non-common law jurisdictions, where the mineral is not owned by the state, it's not owned by the crown.
Yes, I think most jurisdictions they still maintain the common law provision. I think it's Bougainville mining law that do away with the crown ownership, but I did not do a thorough reading on that.
Do some research.
Yes,
that would be helpful to us.
I think the Bougainville Minerals Resource Act 2015 did place the ownership.
In the U.S. is a common law jurisdiction?
U.S.
Former British colony.
Yeah, but some of the how they operate the system is a bit different too. But
maybe different by state.
Yeah.
But I think in some states in the U.S. also,
yes,
mineral is not owned by the state.
Yes, because most of the minerals ownership there is influenced by English common law as well. Yeah.
Well, have a look. It'd be very useful to us. What would be great is I suppose this provision here, which is a repetition of the current law, position or current legislation here, comes from a fear, I think. Me, it's an irrational fear. The fear is that once the state relinquishes control or ownership of the mineral, then it becomes unfair to the rest of the country, that they won't share in the benefits. So they're conflating two issues. One is ownership, and two is sharing of the benefits. But sharing of the benefits really is a matter for taxation.
Yes, the state can get other sources of money through taxation or other things they get apart from what's supposed to go to the resource owners or the landowners.
So if we can home down on that, then that assures, takes away that argument. And therefore we can say, well, rightfully customary land, crown can be or tribe or
Yes, because royalties as before, they pay those royalties on the basis that the state will use the money to provide for social services, and then later on this argument come in that pay those royalties so because as a form of compensation because of using those non-renewable resources, and also by using those non-renewable resources also as a form of compensation due to the negative consequences that this operation will happen or will have impact on everybody, those lands. Yeah, so those are some arguments why this idea of royalty, and of course the economic rent they call it economics, because we are allowing you to use this, our resources, give us a share of it. Yeah, so but those all attached because royalty attached to the crown. So maybe for us, if we are to do away with this remnant of this all English law, instead of saying royalty, we can say mineral owners payment, something like that, instead of saying
Well, you may pay royalty law logging too.
yes, because it's come from the logging sector. I'm not sure how they connect royalty to it, but for the mineral sector, that's it, because of only the royals can own gold and silver. Yeah, so they pay those things direct to them. So law 1568, when Mendana come discover Solomon Island, and call him Yumi Solomon Island because I'm found him gold law Yumi. That was when also case here. 1568 case, the mines case where decide law their lawyer England about what valuable minerals here. Only what people who standing those what call the most excellent people in society, which is the kings and the queens, no, so on them, and then continue to have income. Yes, that's just a bit of history about this royalty thing and the crown ownership. Yeah, but from common law. So for us, we say okay. If we had to say we recognize people and then we allow them to participate meaningfully in decision making of these minerals, then by good to us. And in that, we are not alienating them from their resources. Because at the moment, I think most resource owners, landowners, stand on what's no, while another body dealing with this. So maybe one way for us to allow them participate meaningfully on the mineral for the use of their resources, maybe get them onto the mineral boards, even though Okat Nogare maybe the expertise, but at least where the land in question not land lokata, have them in, so that they're part of it, because all we want is for them to see their connection to government, work together with them, we develop these resources for the good of our country, something also. So yes, so that's for that on mineral ownership. Okay.
Chairman.
Yes.
It is for, I mean, I think this is an issue that we've been raising all along, and me thank you for hearing that one. I think it is very important for us to especially consider land-owning groups when dealing with mining. Para mi hearing that one, me para happy them, and I think that is very important issue. Most of the time, sometimes me just forget them no more the landowners. I think mostly, if you look around the mining operation system, the landowner barawa safana, and I think that is a very important point that when we deal with him mining, I think the people, the landowners are very important to, even like what you have just said. I think it's good to, sometimes you may neglect him out for stapler board. What are the garem? Some people are thinking wisdom, so I say God give him water. Traditionally, also I talk on behalf of people, water. Losawa something will buy him in Sabe. So I think it's good to look at those areas, or include. I think now this time in Migarem, even water tribes and water landowning groups, they have or the picking water well educated. They're school, so they need to be like inside the board. So that's something that considering talking about land is used in several areas or some, or those are contributed or some. So I think me just like for reaffirm what you have said, me really happy with me.
Thank you, Thomas.
So much, Chairman.
Thank you so much, Honorable Member Blow. Ismail for the comment. Yes, and one reason why we try to emphasize of this is because at the moment, even though you may garem this fala people and government, wafala High Court case law 2005, I'm still maintaining that crown ownership. So, but that's because the act tell them. People and government, then how for deal with him completely alienating people from everything through the ministry. But if we bring them in part and maybe, and that's one argument we say, we do away with the service access agreement because under this bill, they say access agreement, but that's stem out from service access agreement where in the current act no more. So if we do away that thinking and then we allow people to, okay, if we say we do away with royalty too, we come up with a new name and then we give them certain percentage, more percentage for the landowners. Government, you can take your shares through other taxes, and also maybe we allow good for people to be part, to share in the company too, so that they earn dividends out of the operation. In that, by with idea of we say the government and the people, they work together with the investor to develop that sector, and then everybody be happy. If no more, after how many mining migarem company come, then people by still or complain no more, and people say me feel no benefit out of it no more, because you may no involve in Oketa and to have meaningful participation on the use of their resources. Yeah, so company, you come with your money. People, your share, that's your resources. Get it as certain parts of the share. So yeah, something awesome. Okay, thank you. I move to the next
Just
point.
before you move.
Yes.
So the current common law, so-called possession law, 6 feet here. So anything below 6, anything above 6 feet, landowners are digging themselves no more, man.
As I thank you, committee member and leader. As I mentioned in my statement, issue of 6 feet here, me bago no come across law and the common law readings below me. Me only come across time me reading mo documents below Solomon Islands, and time me go story with the people of Solomon Islands about land. No more na me hear common law 6 feet. But law readings where me say find him anything law common law or from or the literature where me read him, me no come across any concept law 6 feet. So concept where me come across no more as me same stem out from the mines case, the case of the mines, yeah, where the royals na on him the valuable minerals, yeah. So
Yeah, there seems to be an inconsistency. Bauxite law above ground no more. But again, I'm treated as if it's under 6 feet.
yeah.
And law here, I'm in or on Solomon Islands land.
Yeah.
So now, say no 6 feet more. Anything laid down on top, law stay too.
So, yes, so as I mentioned, according to the common law, I understand, me no come across 6 feet concept, but the royals, the crown ownership, yes. Yeah, so that's why they have crown ownership, and in order to access them, you need this service access agreement to get there.
Yeah, go ahead.
Yeah, so on clause 9, we are just raising a point to there whether the meaning of mining include exploration and prospecting. So we just raised that to see. So if both are included, then that should be good. If not, then M should be included so that part 10 law where deal with environment on mining activities, M are covered. So that's a point we raise for clause 9. Then on clause 13, we raise that water catchment area should be mining prohibited areas. Should not leave it to the mineral boards to decide whether or not to recommend to the minister to declare as mining prohibited. Because they are thinking of water catchment area, we need to preserve our catchment area for water. That's the source. We don't want to have all our rivers or streams run dry because no more water now. This catchment area, what money mining loyam too. And we all know that activities in relation to mining have no good too much for the natural environment, believe me. So to us, those areas, we should leave him out now. That even that those catchment areas within the tenement area, because tenement area are big, but at least you restrict him now that these areas, why we not go touch him in activity asylum mining. Yeah, so yeah, that's where we're coming from. Then on clause 14.1, we say, yeah, you need to add the word mining so that it's called mining before private area. Because I think it's just something, they just miss it instead of adding the word there. They need to add mining there after A and before prohibited areas or prohibited area towards the end of the sentence for clause 14.1c, and then that's clause should be okay. That's for clause 14. Clause 16, we suggest that there should not be any granting of mineral tenements, including building material permits over a mining protected area, because the current clause 16 to us also may defeat the concept of mining protected area if you may allow for mineral tenements smaller there. So we're just raising it. The sponsoring ministry will look at it and take it or not, but we just think that it's better to raise it here.
Were you part of the consultations for this whole bill at any stage?
I think the discussions, like most of the meetings leading to the development of the bill, yes, we were part, because I remember me and our officers, we attend some of the meetings. But for the actual document,
right
now, mifalan no. Yeah. Because I think the ministry did a lot of, they hold a lot of conferences here, workshops before. But to get this bill to come and okay, you may look through in detail, that's one no. Clause 23, so clause 23b states that the regulation may provide the penalties for non-compliance, and they for section 14.1 and 17.1. Yeah, so we are just thinking that it's better to provide those penalties in the act instead of waiting for regulation. Because if you want to create an offense, you create those prohibited conducts, and then you attach a penalty to it, and then an offense is complete. But I mean, if you go for penalties, go regulation more.
Yeah, this is a recent evolution. We're seeing more bills coming before the committee that's leaving the creation of additional offenses and penalties, Golo Minister, by regulation. It is a bit, it's very concerning, because obviously it's better for Parliament now for creating offenses and attaching penalties to him. Also almost as if, well, we don't know what might happen, so we leave him what are fairly large powers.
Yes.
Golo Minister now for doing.
Because offense, as we know, and complete if we attaching penalties. We create those. The prohibited conducts are already in the bill, but offense penalty no more. Okay, say waiting for minister make it through regulation. So I mean, if even this act come into force, if minister now make a regulation here for those penalties, nobody will be charged for those prohibited conducts. So that's why it's better to have the penalties here, so that when the bill pass, enacted in Parliament and become law, and then they gazette it to enforce it, commence the act, the provisions there now, penalties come with. Prohibited conducts, penalty. But if we may pass him law but no more penalties, baka no charge him anyone, because no penalty is law. Yes, so we just think that come with a complete package now. Why not leave him penalty of a minister for this Edmund behind? Yeah. Yes, so that's for closed. So 23. Clause 24. 24.1 empowers the minister to grant, renew, vary or surrender. Oh yeah, this clause 24 and clause 25, we see something as some inconsistencies here, where we think it needs to be clarified. Because clause 24 is talking about the minister who are responsible for giving this approval for these tenements. But clause 25, if you look at clause 25, second part, I'm mentioning that director approve too, yeah. If you will, for certain tenements, 25, clause 25. So 25.1, yes, the minister, when talk about this reconnaissance permit, prospecting license, feasibility, mining, and dealer's license. Then clause 25.2, director in relation to building material permits, community mining permits, artisanal mining permits. So we are just raising what scheme we should follow everything, because we see as from our points we raise certain inconsistencies on this point where we flag out certain provision later in the bill, where sometimes Salem director, sometimes Salem minister. So we raise it to ensure that at least everything power what if you mean like golo minister na or director law certain parts, and then you will make it consistent throughout. So that's our main point in relation to raising clause 24 and 25. That's something for the sponsoring ministry to have a look at.
So this would be helpful to the committee if you did perhaps on this point did a comparative study on what the law is and practice is in New Guinea, Fiji, Australia, for you looking what now other common law jurisdictions doing, what now powers where me responsibility below minister for exercising, what now below minerals board or equivalent below him, and what now below director.
So for neighboring countries,
yeah,
and Australia.
So we get the benefit. I mean, they've been mining much longer than we have, and surely they must have learned a thing or two, strengthened. Our experience, limited as it is, has been minister been abusing more power. Well, ministers, and so. We've had various allegations of ministers go collect before time. Minerals board him say no more, but him say yes, what kind something also. Should more of these be powers that should vest solely in the minerals board, and then minister acting on the advice? This was on the recommendation here. We start for looking at new drafting this time too. I much prefer acting on the advice. So the minister really has no discretion, but as the elected official representing executive government, obviously him exercising the full power, but him removing any discretion. Later on, when we come to, we forget them way about minister may write to applicants and tell them what the status. What a load of nonsense. Mane by office and chiefs no more. Ministers should not be in that kind of position. That's a matter for secretariat or director or something else. What do you put them go kind also work also for minister?
Yes, the use of words consent me for some for clause 25 and 24. One part of issue recommendation, one part of issue approval. So yeah, so they need to clarify that to make it at least use one as where simple for everyone understanding what the law intends to, or the yeah. So that's for clause 25, and so 25 and 24 and 25 we put it together, and we raise other issues there. It's all relating to that. Clause 26 is about the penalties no more. So we make suggestion for some penalties to be increased, and that as a committee you may know, it stem out from our baseline, which is the penalties miscellaneous amendment act, set the framework we often argue for. So that's why we raise those.
So the other bill we finished yesterday was the public service bill. So again, they had this problem. So we directed the legal drafts person and PS for comeback lawyer for that analysis to make it, the equivalence analysis to be done. But having said that, 2009 is a long time ago.
Yes.
And is there a need for either in these more modern, latest bills or that follow miscellaneous penalties?
Yes,
provisions enough to be updated?
So maybe if any concern with the issue of penalties, what
do you have concerns?
What might happen no more is we just need to raise the value, because at the moment one unit equals to $1.
Right.
So we can just raise that, but the standards we keep it there.
Value in the miscellaneous penalties.
Yes, in there.
So we'd have to amend that. What's your view? I'm out of date. I'm low now, or we should up them, or well, anyway, have a think about it.
Yes, at the moment, to me, at the moment, the penalties, if we follow that, the penalties are high enough. But if there is a concern about penalties and no fitna, we can just raise the penalty, the value for the penalty. Instead of $1, we can say $3 or $4 or $5, and then amount here by go up now. But the standards were 6 months equal to 1 year equals to 10,000 penalty units. I think we keep it that way. 2 years equals 20,000 penalty. Yeah, but the value we can add if there is need. Yeah. So that's for clause 26. 27. Yeah, 27 we just say it would be more better if we may leave him this for artisanal mining, say for the customary landowners or association only, so that any economic and social benefits stem out from that mineral tenement or cannot benefit him. At the moment, we may leave him a bit open for others to become part of him too. So I think if we want for our people to participate in this, leave him go for Okatana. Those were closely to that land.
Artisanal mining, not man taken pan go panning. Is it what artisanal mining is?
Maybe by Osimna at small scale mining, where long miners na by sabi good, but thinking lo me by Osimna, what's more
panning.
Where I no sabi use him or machines, small scale. Osim at the moment, Alfil something Osim. Yeah, so you should leave him go low at land owners, resource owners, place block at what do you instead of allow anyone with money come with him or might cost him some raw between Ogat there too, because by you looking at somebody now with money by a little bit doing more aggressive in this area. Yeah, we just raised that. Then clause 28 too. That's just relate to the point we raised for clause 24 and 25 about those inconsistencies in the bill. And then we come to Clause 45, liability upon cancellation. So we're just raising this weak question. We say, why not provide in the bill something like a mining bond, where the holders of the mining license are to pay prior to commencing the operation. This will ensure that companies are more responsible and with their exit strategy. Because you may have, we already had instances where a company did not pay royalties. As you look at newspaper, title shipments, royalty not paid. So in those cases, when you have mining bond, that money can be used to pay for that. But then we say the mining bond can be paid to the mineral resource special fund as established in Part 14 of the bill. But then we raise another question. The liability as anticipated here can be considered taken to be a financial assurance, because that's the thing. We say something like financial assurance scheme under clause 114, but we don't really know about how that will play out. But if I'm not taking care of this liability, maybe we should have something like a mining bond where make a company time I'm doing work out if me doing wrong, but me put on face there, but me no sabe take back na.
But usually the mining bond for rehabilitation, an environmental bond as opposed to cover many royalty.
Yes, but we can use that to come in areas because if you not get anything for example, non-payment of royalties, how now we ensure the company pay?
Chair, is there any way of look at the bond, like royalty bond, environmental bond? Is there any way, Mr.
So maybe the ministry can just consolidate everyone into one, and then we say these ones can be paid on these certain circumstances. So environment come, yes. If you know doing a proper closing law mine after you go, you should this one. Royalty, if you not pay him this one. So we lump them all together because our laws stem out from practice of other countries. But other countries have not considered the practice in reality how things happen in Solomon Islands. So you must respond to the realities here because certain things happen here which is not unheard of in other countries. You have to cater for to whole companies responsible for too. So if we must have expand law or the traditional bonds where available under the mining scheme say to cover other aspect, well, I'm good because at the end of the day, you company no more. Company failure or maybe failure of the enforcers too. Officials not doing part blockade to ensure that this company do this thing, but you part of it. Yeah.
So when the companies, some mining companies anyway, time would come up here before Bills Committee, or let's say that commencement part low mining, I forget what the different stages of it say, but what set up, then go for production and also capital intensives. And so to put up a total bond for environmental rehabilitation upfront would be a huge obstacle to, they need all the cash, well, most of the cash they have to develop the mine. And so I propose him that perhaps one way forward would be to have a phased bond scheme, where upfront there'll be some, and then a little bit more on another stage. Then once they start making money, they can then pay up more. Something also. Again, it would be useful to see how it's done in other jurisdictions, whether this one may work. We just, if we think about Renal, bauxite mining, I don't know whether mines or kata imposim that fall bond and whether it was paid up. If it was paid up, I think what misusing this was no any rehabilitation happen lo there. Or did they waive it? And that's the other problem, the way it's worded. An environment bond should not be waivable. It should be realistic. We don't want to impede mining companies doing the work. Same time, we don't want to give them free hand for disregard them no damage or kata do him.
Yeah, I think the concern raised by the companies reasonable no more. But then they need to pay before the next stage, so that at least keep him aware that we have spent some money on this. If our practices not comply with the law, by me no sawa taken back, recover back, slain yeah. So yes, that's something workable for everyone, because this industry, everyone should work together to progress it for better for everyone. Yeah. So I think what I suggested, I'm okay. At least, excuse for runaway no more than you mean now, but at least some money there. Yeah. So regardless of what paying stage by stage, then it should be okay. At least.
So that's the other aspect, Liam. So do some research on this for helping me too. The other aspect now is, case Loreno, how a company can just get up and go and vanish into thin air.
Yeah, well, Loreno, state shipment royalty cannot pay me. To me,
and no any export duty too.
Yeah, export duty no more because we exempt them.
Correct.
That's the reason. So that's clear now. You may export them, you may exempt them from doing that. But for the royalties, to me it's come back law officials no more. They shipment them go what never to do. But maybe officials by maybe some no more to no garang capacity for go there. So, but if we don't have the capacity, we should not involve in this mining.
Correct. Yeah.
Yeah, because we only give license to venture into mining when we know we can enforce the laws.
Yeah.
That's right.
Because the royalty law section 45 clear no law current act is for the 3% sharing 1.5 for landowners. Yeah, of what way we can say 40% for landowners, 10% for province, 50% for government. I'm clear no more. Why officials no enforce him? No, me no say. To me, it's issue of compliance, no non-compliance.
But I mean, in the law, there must be protection.
Yeah.
That.
So that's the reason why in one of our comments we raised that. Non-compliance by officials, you should punish him.
Yeah. But on the part of the company, a company cannot just vanish into thin air. Like one of that for company, I may do him. So I'm just vanish, liquidated, voluntary liquidation. So deliberately avoid him every liability.
Yeah, because everyone contribute to it. Yeah? The company and the officials.
Yeah, but let's focus on the company. So officials, they must be held accountable. There's a limit to that. You can send them to prison. They can fine. A year's salary, it's not much. But the company now, you must hit him with good here. So a company cannot be allowed to just go for voluntary. If it's an involuntary liquidation, I can't say no, or bankrupt through,
yeah.
But a voluntary liquidation should be prohibited.
Yes.
Law here somewhere.
Yeah.
And then to make matters worse, more Loreno situation here, or the same shareholders, directors, that company when vanish into thin air, or go register more a new one more, then not more go hold more license this time more. You mean all right or what? It's just unconscionable that you mean lo solo no, you karang also mean.
You should blacklist him for the operating business law. Yeah.
So it should go beyond the company. It should go to the directors, shareholders, the promoters, whoever was involved, lawyers, bloggers, whoever was involved in it goes onto a blacklist. They cannot again engage in anything to do with it.
So it's something that I think the committee can raise with the sponsor ministry to have that in the law, clear law.
Have a look at what is done in the region.
The region, yeah, as I mentioned, most of the countries for region, the framework aims stop us in most countries, no, because kind system way me operate in no country blue me, okay, no sab do me.
Oh yeah.
Okay, comply with, yeah, at least they comply. That's the general.
You check them good on New Guinea. I mean, okay, now. Where blood calls also maybe 2 years. So,
New Guinea.
but maybe they've had years and years of.
Yes.
So
Yes. But New Guinea, not sure. But you mean since that situation happened in the country, blame me. Those instances, you may need for provide for in the law for stopping those people for animal or attack. Similar company or similar country, believe me, because they are not responsible investors here. They are not genuine. You doing a business and then you just leave you no more, or you never meet your obligation under law, then you lack for start narawan mo. And then come back law, you me too. Those who are giving them the license to operate those. Why are we allowing them to do that?
Minister, problem of minister. So no what board them decide no more. Minister I'm go overturn them that one. So
then it's come back to us. We can have our laws, better legal framework there, but when we not enforce as we intend,
That's right.
why any problem no more? Yeah. So yeah. So that's for that. And then we move for clause 49. Yeah, clause 49 about government not to have financial information law this for sector. So, but as law point, me was starting from the argument that government should work together with the people to develop these resources. We think that government you should partner him. You should provide financial assistance where required. For example, there might be some resource owners who want to venture it, but they may got a little bit handicapped because of finance. Why not government support them to get this done? Because after all, we need money in the rural areas. We need money in our communities. Government will take no more, because these monies by come people top up him. Government you take him tax law, pay him tayo law, you take him good service tax law. When we have more money circulating in our country, it means government will be take no more. So it's good for government for help participate this in this sector, with especially for our people, resource owners.
So you're recommending it should be deleted in its entirety?
Delete, yeah, so that governments himself participate.
Yeah. Option for him engage.
Yeah, engage. Yeah, because if you stand out, when we say, we regulate team no more, you will go at play na.
Yeah.
Yes, but the big players, yes, they have the money to do that. But our local people, resource owners, where they want to do that thing by themselves, by no more, and who so should come lo him na, you set them you finish it. You say no more, but locally na, me fall by now participate. So
I don't know where this came from, but again, have a look at the region. I mean, New Guinea, we hear the government's taken over. Was it Oktedi or Pogera or somewhere?
I don't.
Or it's
not
taking
sure.
over more and more. Government's intent on having more stake in mining operations. But you mean here, you mean like for stop him? Look, was one woman bribe him and one who put on this one here. It's for stop him government from being involved. I mean, this is a sector that should be in its entirety nationalized.
Yes. We need government to support.
I think government should support.
I'll make a comment. Sorry to jump in.
No, that's okay.
Sam Kaupa, I'm the Chief Mining Advisor under the World Bank SMD Tech project. I'll talk later, but this, I think I have to jump in for that one. I agree with my brother here that that particular clause has to be removed. PNG, they have an SOE called the Common Minerals Holdings Limited. I put it in my presentation there, which I will talk about it later. And this, the government becomes direct equity holder in projects, in large projects. So the particular company has taken over Oktedi. They've got shares in Pogra. They've got shares in other upcoming
What
projects.
percentage shares?
They have in the policy. It's never been in the law. It's not in the act, but they have this the policy that is been going on for a while, which is for mining companies, the government has backing rights for at least 30% in mining projects and 22.5% in petroleum projects. Petroleum projects, shares, direct equity. Petroleum projects are held by Kumul Petroleum Holdings Limited. They're now playing the same level field playing partner with ExxonMobil and Santos and all that in the big LNG projects. And Kumul Minerals is also doing that on the mining front, going into organic growth projects or brownfield projects. So instead of being spectators and collectors of rent, the government is actually in there as equity. And then from the government's equity, it gives direct free carried equity to the landowners, like 10-15% to the landowners. So
As part of the government's equity?
the part of the government's equity,
30% to the government?
30%.
15% of that?
15%, now they've given about between 10 to 15% to the landowners, free carried. So landowners are part of the project as
Right,
an equity
right.
holder. So we'll talk about it later, but I just want to,
Why didn't you put it in the bill?
I came late. The bill was already drafted.
Talk about it later.
Yeah.
We'll talk about it, but I agree that we can't hang ourselves, right? Someone else wrote the law for us. It's the same as PNG. You talk about land ownership. They adopted what they call terra nullius. In the Roman times, they said it's no man's land. And that's purely for civilized. They conquered every area the Romans conquered. They claim it as no man's land. The British actually adopted that, and then when they came to Australia, they adopted the same thing. The Mabo case overturned it in Australia, but it was already written into the PNG Mining Act. It was adopted in the 1992 PNG Mining Act. It's a complete replicate. Cut and paste of the Queensland Mining Act, and I am sure it's the same here. I've done my research, but the question about is if the law doesn't work for us, why should we keep it? That's the big thing, and I think my presentation would basically not touch on all this little nitty gritty, but what does the country get out of it? What does the people get out of this law? If it's not good, why are we entertaining it? That's really what my but thank you. I'll just jump in there for the state ownership. You can do it. As a state vehicle, you can be able to do it. It's done everywhere else. Why are we not doing it?
Thank you very much. Thank you. We'll hear more on that when you make your presentation. But thank you for coming in to help the committee understand that clause. Please, Chairman, continue.
Thank you. So I move on to clause 77. It says it just is a point that we just need to remove anything relating to access agreement in this bill. And then clause 79, 79(3)(b). So we raise the question: why exempt from complying with Part 3 of the Environment Act 1998. This provision should be deleted because activities under mineral tenements are generally not environmentally friendly. So the Environment Office need to examine the operations before those mineral tenements are granted. Yeah, so we just raised that for the sponsoring ministry to have a look at. And then on clause 833, we say for those land, it's better to have the land recorded under the Customary Land Records Act, which at the moment the Ministry of Lands, they are doing a program of recording all some customary lands. So I think it would be better if we can follow that approach. If you like mining, you record in land blue. That's so how you strike the mutual phase at the community level. Then before you be involved into land recording would be a good approach to use. Yeah.
So the Commissioner of Land was here, and he raised that. Said right now, the current legislation, it's not very consistent with the Land Titles Act. So when you say a mining lease, it's actually not quite the same lease as a lease under, an FTE lease under the Land and Titles Act. So he made some suggestions. He was disappointed that his recommendations weren't taken up in this bill. But I'm wondering how it's done. Because customary land too, tribal ownership too, long PNG.
Yeah.
And how do you go from land recording? So you record the genealogies and the boundaries, the tabu sites, and so forth. So once that is clear, how do you then convert that record, become a fee simple that can be leased?
For us, the argument is when we record everyone attaching to that particular land, means we record the genealogies. So everyone in that particular area, everyone logat na. So the question of who you should deal with, not really an issue, no, because okata organized finish. So we can just deal with them as those people who have the right to say whatever, allow whoever come into the land. So we deal with them.
So no need more for registration under Land Titles Act?
Because at the moment there's no registration. At the end they record on all those records or keep him normal or register of titles. Yeah. So because we know current mechanism where enough for doing register and then what's call them what a customary perpetual estate or whatever. So long as the records are there, investor and government, you treat him that one as some good title for you deal with him, not people or leaders block in relation to for that land, particular land. You deal with that people because obviously when a piece of land or tribal land to be recorded in the country, by okata issue block coordination okata strategy ogat sa level na ya, by strategy okay Yumi or same by you falana be part of this some executive leaders block it but identify me even though no customary land records act no require, but internally they will be doing that because that's how the people blame it over the years been doing or try to form themselves.
But we know that has been problematic. I mean, one of my expectations was that there would be either come part of this one or a separate legislation, either amending the Land Titles Act or something to do with trusteeship, so that once the customary land recording process is complete, and then that law would kick in as to force that tribe to be better organized, governance blow tribe level, so that we don't have issues that we have, royalty payments or man go darangalo no go and finish. There is a fair distribution of that income and the rest of it. That needs to be legislated, but as part of a broader piece of reform. It's not here, and probably not the place for it to be, but it does need to accompany this.
Yes, so at the point that we still to have that, for us, our point is good records now with him doing through the process of customary land records. When land is recorded, the government and the investor can deal with those people because the good thing about keeping them all same land continue to be custom so now when I release more then go issue about exclusion
That's true.
So for us
Chairman, so when we do the land recording, we really safe because also other customary land beside will also give their the approval, there's boundaries. Yeah,
Because that's the process, honorable member. Because if for him record him area for him straight, or what nearby tribes na become support yes, him straight. So if everyone nearby support na, who mo ba you come in and dispute him? At one him straight na. So we think it's a good fair call for government and investor for use for deal with those people where what record them land block at. For example, for mining, if you like a mining, you start them. You was them will face.
that's right.
Go approach the Ministry of Lands, select them land record set. Then we can deal with it. Yeah. So that's for clause. That for la clause 83.3 and clause 84 and 85. From clause 7, we just say delete the clause as they. Oh yes, it's all relating about this access agreement. No more, so we're just trying to do away this type of. And then when we go to clause, the clause 113, it's on these penalties. We just think that penalties should be increased, as we suggest the penalty there. We raise a question about clause 114. We say, can this financial assurance scheme take care of liability envisaged under clause 45? We do not sure, so we just like. And then clause 116 and 117 on royalties.
Before you go to that, because that's a substantive issue, you make a comment, clause 105C.
105C.
Authorized officer.
Yeah, we just want, who is this authorized officer? We don't know who is this authorized officer. So
Him listing authorized officer could be police officer, blah, 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 blah. Or police can take exception to this one. Let's say if a police officer, him authorized officer under law here, him take an instruction from someone other than the commissioner of police, then him run afoul of commissioner's independence law constitution, which is sounds like a fair argument. Could you have a look at that and give us your view
on clause 105C.
105C
in relation to police, yeah?
in relation to police?
Police as authorized officers.
Yeah, and look else. I can't see it now, but elsewhere, let me spell him out who could be authorized officers, including police.
Okay, thank you. So that's for that. And then back to the issue, royalties. So in clause 116, we say the clause should be just simple and direct to the subject. Because at the moment it's confusing as to how now you do royalties allocation. So what the clause should do is just to specify the royalty rates in the act. And the percentage to be received by the landowners, province, the government. Leaving it to regulation by problematic na, because regulation yung decide law minister na. As you may say, one example of leaving things to regulation na, happen law immediate 0% for export duty. so it's good for making everybody certain law issue law this royalty payment, or we say mineral owners payment. We clarify them gonna make them law and clear law them no instead of puputum for regulation.
Chair, just a little bit question. So if we featured in the act, but then later government want to increase.
But then amendment.
Amend. Okay.
Because the good thing about coming to for amendment is, at least by you amending by needing both sides of the house, but protocol him.
Yeah.
I have no regulation. Ruling government no more. Mo kata imi osem.
Yes.
No more to one woman no more.
So it's good to.
So we think it's better to make putum law there, and then the calculation at the moment we know what na basis law the calculations this time. Yeah, but I think it's good to have. But if landowners be part of the company, they have some shares in the company. No matter royalty, not a big percentage, but okay, no, because okay, by getting dividend through their shareholding arrangement law company, no, because they as them as being owners too. So I think that's what we should encourage him. Yes, they can pay certain part of royalty because of your land resources, but you too, you part of the company, and you can in shares time company make a big profit by shareholders should happy too. If no more, by can say no, because it's a risky business too, mining. Yeah, so I think we just think that it's good. Yeah, and then about this for royalty, yeah. Yes, that is making some people might think because royalty mostly am linked to the crown, no? The royals ownership of minerals as in the past stem out from the common law tradition. So if you need to do away with the idea of royals as royalty, you may talagang go straight no mineral resource, mineral owners payment. Because even no royals, no anyone like me royal or communities. So because the word royal, the royalties, something we used in the past when the crown, the kings and the queens now are the owners of these valuable minerals. Yes, just for that one. No. And then move on to clause 120. The clause should also include a provision to punish those government officials who fail their duties to ensure that the royalties are paid and taxes are paid also. Or you mean must punishing people? Na? The time you mean no punishing people by close practice by continue to perpetuate. So that if you may say, oh, by you mean no enforce him law because you mean no garam human resources. Well, meaning that you should not give him license. We hold on one step. We need these human resources in place before we proceed with involving in this industry. So that's our point there. And clause 124, we raise the point of why mineral limited to gold, gemstone, or building materials, as opposed to the broader definition law clause 9 about minerals. So even dealings in minerals under the subsequent clause 125 also deals with other minerals apart from gold, gemstone, and building materials. We're just raising that point for the sponsoring military to have a look at. If thing him OSEM supposed to be OSEM as 124, I'm okay, but if I'm no, look. Clause 139, as in clause, that's in relation to these penalties, no man, I already touched on that. Clause 148.
Just before you go to that, let me take you back to 124 here. This was gold dealer's license here.
Yes.
Current practice here. So gold dealer's license here for islanders here, so indigenous Solomon. But we had the gold dealers here too here for come present before the committee. As it turned out, all of them have licenses. None of them have cash. All of them have foreigners behind them. And then most of them, not all, most of them, time mogata export go, sell no come back, so cross law foreigner. And then time would go for second export permit molo central bank. No give him, central bank less or give him because ought no account for selling no come back. So they're not cross law foreigner block at but the foreigner is free to move between each gold dealer license. So I'm going to use him narrow one more, then go use him narrow one more. It's obviously an abuse of the license, both by the gold dealers themselves, but also by those foreigners who could not have a foreign investment license to do that kind of practice. But how it can continue for so many years and just blatant OSEM no more with absolutely no accountability is a bit of a problem. How do we how do we bring it to bear? How do we close that? It's a loophole.
So maybe one way, if we allow the government to participate in the sector, we put the government as the one who buy them all the goals here,
As the buyer.
as the buyer.
So if you like sell, compulsory, you sell
Yes.
for bank.
Sell na. They no allow more. Okay, landowners where you take a permit for doing more small scale mining, you come sell the government. And government sell na.
Yeah.
Something also for avoid them na kind where you may like him license no more, but narawan mi no garam sila ni.
Yeah, it's speculation.
Yes, speculating. Yeah, so I think that's an area I think good for if government no may involved. For satem gonna yes, landowners you like participate, you take a permit to you for you doing this for small scale mining, and then come sell government where operate for buy them and then them sell them over the goals here on behalf of them.
The unintended consequence is fueling to this illegal mining activity of Gold Ridge.
Yes.
So you've got all these guys up there putting their lives at risk because they can come and sell to so-called gold dealers.
Yes, and that one, if government na buy, at least we also control him too, yeah. Because they only receive from the permit holders. Yeah? So also, why the question people might ask him, why more if I like man with him permit no for come sell him, you know, resources if I na on him. But because we mean like for regulative no more, at least environmentally activities block at them safe because under that scheme, if you to take a permit, you have to state your work program is how you will do that. This is good for environment there, because if you reckon that environment in a particular area, it not only for landowners that particular land no more, but if affected the entire region or the whole island, by everyone sawana, but only few no more got the benefit of selling the gold. Yeah. So that's why those regulatory schemes will come in for regulating how you extracting those minerals, even though in small scale, you may need for regulating. That one, no, some people believe we need for understanding so that yes, same below you here, but we regulate it to ensure that you not causing more trouble. Nara brother and sister believe live down the other part of the land where water block at now so come now because of that water dry up na. You will spoil them come on top of source finish na. Yeah, so those things. That's why government name part to be part of him. Yes, that's the reasoning. Thank you. And then we move on to where we are now. Close 148. 148. Oh, that's basically same thing for the penalties. And then close 176. The law should, we say for the board, yeah, the law should prescribe at least 2 appointed members, a person with qualification and experience, where appoint them as like director of mines or like people with background, technical areas in that area for to be members. And if we need to bring the landowners in, we should allow at least 1 or 2 follow blocked from the tribe where land blocked by of consent, or to be part of the minerals board, so that we allow them to participate in decision making over their minerals. Make them to serve the time we go part of that board. Me now, but me make decision as on behalf of my people as to who now will come in and do prospecting, come do mining, yeah. So it takes a responsibility, and whatever you like for raising, you can raise with the board. Because you just try to get them part of government. Because okatna honest, yeah.
The counter to that, of course, is, as we've seen with many of these mining companies, or to go or to divide them families, divide them tribes against each other. Eh?
Same as in logging.
Yeah, same as in logging, same behavior and transition, migrate across. And so if or to take him, we hear of cases, Lo Isabel, for example, where it's all over, where brother against sister no more and also. So if say, the brother was invited to be on the mines board to consider a matter for that particular mining tenement, Miami might be a little bit dangerous, prejudicial to the rest of the tribe, because he's been bribed or bought out by a particular company.
Yes,
That would be a risk.
we cannot rule out those risks because people believe me vulnerable.
Yeah.
They vulnerable to, because you mean no garim also money. So when money low there, we are vulnerable to making decisions where sometimes by against him. People believe me too.
But
So
like people,
yeah,
like Ifemi Putumi said, he will be selected by the whole tribe.
Yes.
He will represent us in the whole.
as before mentioned him, if we get it through the land recording mechanism, because tribe should set finish, okay, should start finish unap chairman loga or chairperson loga to secretary or treasurer loga deputy chairperson, so whoever okay or land lo yumina about my name, so you chairperson and deputy chairperson it will part of board go na.
But that was the matter I was referring to for tribal governance. Once a recording complete, law too should impose him by structure for decision making all same. So lo yumilo malate, for example, man now vai now, so I'm not custodian law, tribal rights, no, veto rights.
So maybe one good way to do it is for if all the colleagues, those from the Ministry of Lands, where the land recording, they push it at the moment. Also, if we put them as one of the criteria for consider which area na for recording. You certain finish area governance below you, low tribal level. If below you straight, by me for like I'm doing recording below you. So in that way, even though law no provide for, but they go deal with a well-established structural law governance over that area. And so time complete. They have body to
the nuance of the decay, the corruption that's come into even into our tribes is such that it make them tribes very vulnerable. Also, now, if mining company go bribe him, full tribe, mahem no rightful man, chief true one, There's no doubt about that, but it doesn't mean he owns it on his own. Custody for whole tribe here. So that's why there is need for trusteeship governance legislation to help our own people against our worst instincts, our own vulnerability to. Logging him do him lo yumi finish him. So mining him start do him now too. So ogat looks have to custom log te awesome so yumi go off mogat lo this one.
Yes. Okay, so then what's the other one? Clause 1772, appointed members may resign and give the resignation to the minister. And for clause 173, we say it's better to give the power to the minister to terminate those appointments. And then come back clause part 16, it's all about penalties. Now, Mifala always raise him that penalties if we make him this on the baseline law. Penalties, Miscellaneous Amendment Act 2009 to make the standard, and so that's why we raise him all those number of penalties here and reflect him that one. So
on that score, what's way if so for all other matters, for scheme, any equivalence set by miscellaneous provisions, penalties provisions, straight. But with regards to mining, because we're dealing with big money, perhaps they should be an exception. They should be in a class of their own. Because if you say, 15 million now penalty units, 15 million, 150 years.
So basically, I remember, but really by what the companies, and if we talk about directors, we are liable.
But our experience is you must hold them out directors liable. If you mean no hold them directors liable, you may look in no renal. companies simply vanish into thin air and they walk free and they set up another company. And so we have to extend to natural persons.
Yes.
So maybe think about how that might work.
Yes. So
Recommend to us.
So yeah, because of penalties. So which one are you concerned, lawyer? Penalties here big too much.
No more. I mean, penalties must be. So side law penalty units, I'm hired now, but side law at the ESA, I'm need for reflecting him.
So the propose one from at the ESA, over na. So if one when we first started stem hard at the ESA means if you live, because him lo there na, but you stop lo over. If no more, you off lo there na. We already put them go got a corresponding penalty in number of years lo there too, which is me for increasing. I'm not small.
Yeah.
So, yeah, man.
Because at the moment, the scheme, most of our legislation, 10 years. 10 years is equivalent to 100,000 penalty unit. So if you're looking at 500,000 penalty unit, you're looking at 50 years. If 1 million, it means 100 years, where most by now leave Kasim.
Yeah. So, for example, table blue, clause 187, and 10 million penalty units, imprisonment for 7 years or both, and no maximum under law bill. Yeah. So 10,000 penalty units for someone interfering with activities authorized by mineral tenement. But you draw equivalency, but you use him example or interference offenses under law Electoral Act.
Yeah.
But meeting him, it's not a good equivalent comparative. Because Electoral Act, yeah, important, but interference with him mineral tenement, value below that interference could be much, the consequence of it. We're talking maybe hundreds of millions of dollars in both investment and wealth to be generated from it. So 7 years, yeah, man, 7 years, I'm high, 10 millions, I'm good now, but
because Okate put up 10,000 no at the moment, 10,000 penalty units or 7 years imprisonment.
10 million, no more?
10 million.
10 million, yeah.
10 million. So
187 for 7 years. I'm not me say first time. Perhaps they should be this bill, the mining offenses penalty or penalties law, mining legislation should be different given the consequences.
So means if it's 10 million, I mean the corresponding one should be more than 100 years.
Correct.
Yeah.
So at least 100 years.
Yeah. So not should be corresponding.
We don't in Melanesia. We don't live very long.
No, but at least put to maximum law there for code 7 that no maximum.
Something was him.
Yeah.
7 him.
But
Yeah.
True.
Yeah.
So maybe have a look at it. Give us
Yes.
some recommendation that should not be an equivalent to other
Yes.
legislation because given the nature of this fella sector. Yeah.
So the nature of this sector, so means I'm come back law. How many people think about no one because if we are to
Well, look at what happens in New Guinea.
yeah.
I mean, that might be an indication.
Yes, you see.
I'm just thinking, interference with activities authorized by mineral tenement. So a tenement was given. Another company come, bribe him some man for go interfere to cause him problem, go tenement him out. For him go local company, favorite company blow. Well, that's, you're talking a couple of $1 million, maybe $100 million maybe
Yes.
consequence. Obviously, they might say, 10 million, no anything. It's all part of this investment.
Yeah. Part of doing business.
Yeah.
Which is problematic for you, if you
It's a
go
cost-benefit
for-
analysis, yeah.
Thank you. So those are for the penalties. We will look at those penalties in the context of mineral sector salary, put no others. And then for clause 200, I'm telling about constructive consent. So we say a free and well-informed consent should be required here than a constructive consent. If the owners of the land are not responding, have no minimum or agree. So we should not take it as a consent. So we only know that Okata parties agree lo setting, they give their consent to the thing if Okata clearly agree lo after they've been considering whatever the circumstances or the situations and they come to an agreement. You may not do kind of some constructive consent. We will be not helping our people in this area. And then close.
So what are you recommending? It should go the other way around? If not,
Clear consent na.
Yeah, so if
Free prior consent na. You may not take him as constructive consent. They agree, they say so. Clear.
Right.
Explicitly. Expressive. If no more, if you not respond ka, no more na, minimum ka not agree. Then close 202.
but if it's unreasonably withheld,
Well, that's the something where maybe though they can try to see how to get that, because after all, you mean like him, everyone for agree law, whatever operation may happen, or whatever transfer will happen, you may not like him, you may take him as him constructive consent, then mining happen go, then after people are so me will never agree law this one, yeah. So,
but sometimes consent is withheld because OSME society first time. One for company back and one for part of family. Another company back and another one. And then, so the way to hold it up would be, okay, we'll not give him consent. There's no consensus on the part of landowners to give consent.
yes.
That situation,
So there may be that.
unreasonable.
Yeah, so there may be that situation. Our officials might liaise with them to find out reasons for not coming up. Yeah, do some investigation on that one. But yeah, because
Land block na.
yeah, because you have to find out because for you may say no more ogat money no talaga anything you may take him as constructive na you may should not go that path. Yeah. So that's for that.
Yeah.
And then
So, mid-drum attention, Bligolo clause 193.
193.
Yeah, we talk about authorized officers before, but here inspectors and police commissioner. Me, little bit no mas comfortable with him. This one 1932. Yeah. Say commissioner no was appointed. Police presence commission now I'm appoint for certain levels, and then commissioner now for other levels. So appointment by the minister of a police officer to be an inspector would be an issue for them. And then functions law 194, yeah, powers law 195. If any, because obviously by if any police officer, then hemi by taking directions not from the commissioner of police, then law 197, any offense, both offense law inspector, yeah. So I'm say disciplinary process block it, and clear under law act block it and rules block it. So now this one I move him, I interfere with him legislative scheme block it more.
Okay. So you want me to have a look at
To
it
have a
and
look at that?
send something on it?
Yeah, and have a look at the act and rules here, regulations block it.
Yes.
And say
yeah,
how maybe the neatest thing would be to remove them totally from this.
So from clause 193 to clause 197. Yeah?
Yes.
Okay. All good. Thank you. So we move on to the other clause. Clause 202. Following procedure is an element of good decision. Anyone who feels offended by a decision of a government or body is always at liberty to challenge the decision, whether through administrative mechanism or Okay, so that's close to 202. What we is trying to say here. This is not to be challenged only by illegality. Oh, yes. So, informal making this an element of good governance. Yeah, so our point here basically is if these things belong at officials, duties review and always lo there no matter imi po too many law force tatalem that I have no anyone. It's always there for review. So that's basically the point.
And 202 1B, this doesn't make sense to me. Why would you put that there?
Yeah, it's up to the...
We're encouraging people to not fully comply.
Yeah. Something for the sponsoring ministry to respond to why they put it there at the first place. Yeah. So, Chairman, Bills and Legislation Committee and committee members, those are the points that we wish to raise before the committee to help maybe find some way to fine-tune the bill. Thank you so much for listening to our views. Thank you.
Thank you very much, Chairman, Law Reform Commission, for your informative presentation to the Bills and Legislation Committee. We've taken up some of the comments and questions along the way when you were making your presentation. So if there is any other question that may be directed to you, then we'll take that later. I will now give the opportunity to the consultant from the with the Ministry of Mines, Energy, Rural Electrification. It's Sam Cooper. Thank you. Thank you very much for bearing with us. You've been sitting through the presentation by the chairman of the Law and Reform Commission, so it's his turn to sit and listen, and we'll give him now the floor. Just to...
We can excuse the chairman.
Oh, okay, chairman. Thank you. I think leader said that you can be excused.
Thank you so much.
You have taken up the comments and questions already. Yeah, thank you for that, leader. I'll allow you to introduce yourself and maybe your colleague there, but you are before the parliamentary committee, which is the Bills and Legislation Committee, and we have privileges, as you may be aware of. Let me assure you that anything that you say to us in this inquiry will not be held against you in any law of our country. So that is very powerful. You have our parliamentary privilege. So please share what you have to share with us on this bill, and we are very grateful for your appearing before us. Thank you. You may now introduce yourself into the mic and then proceed with the presentation. Thank you.
Okay. Oops. Sorry.
Please, can you move to the center?
I'll come to the center. I just need to support this. Come to the center. Support this a little bit. Okay, that's it. Thank you very much, Chairman of the Bills and Legislation Committee. members, it's a privilege to be here in front of you to just do some presentations regarding the Mineral Bill 2025 that is currently before Parliament, and hence the current hearing now. Let me just start off by introducing myself. My name is Sam Kaupa. I'm from PNG. I'm a mining engineer by training. I have about close to 27 years of mining experience, 15 of which are in PNG. I've worked in Porgera, Oktedi, Lihir. I worked with the Mineral Resources Authority as a senior manager in the Tenement Registry and Technical Assessment Branch. So I've also worked in Africa for about 7 or 8 years, in the Democratic Republic of Congo.
Oh, you survived.
Also in Ivory Coast, in Ghana, in Mali, and the latest one was in Sudan in 2021. So my roles in there was chief mining engineer and mining manager for gold, copper, nickel projects there, and then I've been consulting with the Department of Environment Conservation in Port Moresby. So I've been doing some consulting before I was approached to take up this role as chief mining advisor under the World Bank SMD TAP project. So behind me is my wife, Leah. She came over on Saturday, so she decided to join me as well. So
You
here
must
I
stay.
am.
Don't go back. Stay.
Thank you very much. Unfortunately, it took me about 6 months to get here because of the protocol and the arrangements. That's been a little bit slow in getting me here. I nearly gave up, but eventually I got here. And during that process, as you all know, the SMD TAP project actually was also responsible for the drafting of the bill. Our legal advisor was a Professor Bukosa, actually came under the project and was actually drafting the bill. And I spent a little bit of time when the draft was under review, so I didn't have a lot of input into it, but there's few inputs I did. Ideally, I want to do some serious structural amendments to the bill because of my experience in PNG. The PNG bill currently, the current Mining Act was the Mining Act 1992. It's a long time ago, so it's about, and the current revised bill of 2018 is still sitting somewhere in Parliament. It's never been passed. They're saying they will pass it, and it still hasn't been passed. But looking at the two jurisdictions, there's a lot of similarities, which I want to draw on in my little presentation. Unless you have any specific issues or some questions that you want me to deliberate on. My presentation is basically, I'm not looking at the nitty-gritties, as you can say, about what the wording should be or what it's and how it should be reframed and all that. I'm just looking at what do we get out of it as a country. Drawing on from my experience in other countries, especially in PNG as well, where I've worked, how can we change the law to fully benefit the resource owners and the custodians of the law? From being spectators to being participating, people, we can participate as well. Why are we becoming only spectators and collecting rent and taxes and stuff like that? Well, the big chunk of it is taken away somewhere. It's like we're sitting there with our legs and hands tied and someone else is running away. And what's the cause of it? If it's the law, why don't we change it? It's written by someone else. And we have come of age. I think PNG is celebrated 50 years of independence just a few weeks ago. And Solomon Islands is going to go towards that very shortly in the next few years. The laws were written by someone else. Under the British Crown law, as I said already, mineral ownership is a big thing. The Romans, when they conquer land, they use this term terra nullius, which basically they take over and they say it's no man's land. That concept, flawed concept, was inherited by the British. Then when they came over to Australia, and then they forgot that Aboriginals were there. So they used the same concept of terra nullius, but Aboriginals were there already. The same, when they went to PNG, they were landowners there. People were living on the land. Solomon Islands, the same. And they adopted that concept of terra nullius. And basically they said what subservice it belongs to the Crown. It belongs to the state. So at the stroke of a pen, they just send it away to someone else. In summary, that's how it's done. Now, it's been the same. I've seen it, the 1996 Mining Act of Solomon Islands. It's been the same. It's the Crown. But the revised bill is now saying that it's the state and the landowners, which is a little bit better than what the PNG jurisdiction is right now. The revised act has actually had a different model, which I will talk about it later. So if we look at it, then if you talk about royalties and stuff like that, royalty is basically compensation. It's a rent, or it's compensation for someone taking your stuff. They have to pay you and take it, right? In the simplest form definition. Now, if you are the owner, what's stopping you from participating as well? Or you just sign off on a piece of paper and you give the ownership away, and then you wait for them to come back and give something to you. And if they say they don't make enough, then how are you going to make them accountable? A lot of companies are smart. They can really reduce the profit margin to a stage where what's left is almost negligible. You can't share anything. So that's how the current operation is like. And what they call I'll go to the different types of models that China uses, Indonesia uses, and we use as well. But what we are doing here is, like, to me, it's like, it's crazy. Why are we writing off the ownership of something we own at the stroke of a pen when these people came with nothing? We said we own it. Why do we have to give it away? Kind of some mitok pisina. Pig blue stapa. You talking narlaman lo kam kill him. But you not decide. Okay, you kill him. Okay, me like him half plus la pig. You agree? Okay, you come kill him. You less, okay, go to narplap. That's what the Africans do. They discuss royalty, what they call royalty, and it's 10% flat. It goes up to 15%. Everything you make, I'll get 10% of it right from the start. You can deal with the rest. If you make money, then you can still pay me the taxes because it's the law of the land. You can still pay royalties to whoever is the owner of that place, whatever, everything else you can do. But as the owner of the minerals, you take it, I want 10% of it. You can deal with the 90%. If you make a loss, doesn't matter. I got my 10% already. Why are we not doing this?
New Guinea, what's the rate of royalty?
No. It's funny. I might get hanged for saying that, but so basically, I can go on, but we have limited time. So what I'll do is, what I've done basically is I've looked at some of the things that we can be able to do almost immediately, or even if this bill gets passed, we can do immediate amendments. Almost immediately. We can be able to do amendments because it's good. It's good for the country. It's good for the resource owners. I've been here for over 1 year, so I've dealt with the Renal case. I've dealt with the nickel mine case. I've dealt with Goldrich in unpaid equity, royalties. I've dealt with a lot of issues, so I'm well informed about what, a few of the issues that's currently going on in the Solomon Islands right now, and the landowner issues like you remember you have already mentioned about the brothers are not agreeing with this company, that the uncles are signing the SAA or the SARA with someone else. They all come in there. So the root cause, PNG, we've gone through that over a long period of time, and we have devised mechanisms or put that into, there's some things you can put into the regulations. You can't put them into the, into the act. Because if you put it in the act, it's hardwired. If a situation, the mineral industry is, evolving every time. Sometimes the price shoots up, like the gold price. If you lock in something in the act, you'll have to take it to Parliament, and you need a bipartisan, consensus and voting to be able to amend that. If you have it in the regulations, it's a living document. You can be able to change it as and when required. You mean him? So there are some things you can put in the regulations. There's some things you have to put in the act. The act is like a building. It's the framework. How you arrange the chairs and the cupboards and everything else. These are the regulations and the policies. You can be able to move them around to suit you. But if you want to extend the house, then you'll have to, take it to Parliament. So this is the type of thing. So we have to come from that kind of point of view. So I will just go through my quick presentation. I think I did a printout there, maybe too small, but I'm looking at the more critical things. I'm not looking at or legal something now. So if I can continue, if I may continue. So. And I'm sure you have questions, which I'm very happy to try and provide the feedback. Okay, so just generally on my role as Chief Mining Advisor, what am I doing here, and what are the things that I've done, and see how that is relevant to the whole entire industry. And then the second thing I want to look at is transforming the SI mineral sector, like the key reform pillars. What are the things that we can do it, which are more important? Something you can live with it. But the things I'm putting down here is the crux of all the issues that we have. Why is the money not coming into from the mineral sector? What is wrong? What is fundamentally wrong? And from my background with the Mineral Resource Authority, which is the regulator, which is separate from the mining ministry who are policymakers, why they were separated and all that, I will tell you. And I've got that all in the mining master plan that I'm currently writing for Solomon Islands, which is in a draft format, and I'll have it finalized. But these are the key pillars, which I think is very crucial for Solomon Islands to go ahead and to prosper. Okay, well, the key pillars I'm looking at is the fiscal regime reform. They're very, very important. At the end of the day, it boils down to money. Boils down to what we get as a country. Sometimes I don't even story. Okay, we can live with it, but what do we get out of our minerals? We sit there and people walk away with it, put it in ships. They go away and then they tell us that, oh, we got this amount, and we believe them. Why not we checking it ourselves? What's stopping us from doing it? This kind of thing. Royalties. Someone set up figure and we're all happy with it. If it's too low, why are we still going on with it? 3% of Goldrich, that's for gold bust. Now they're shipping concentrates. Why are we still applying 3% to concentrates? It should be higher. Raw products like bauxite and nickel.
You must come back. and you stand for parliament here, we will vote you in. You come to parliament here.
Why are we doing it for bauxite? Why are we doing it for nickel? 3%. Who said 3%? What about the associated minerals in there? Critical minerals, rare earth minerals. They're very critical for the defense industry. In, fighter jets, all this space technology. Stucker, full of it. In, Choiseul, Malaita. People taking nickel, they're not going for nickel. I mean, if you look at it, one shipment of nickel is 1.5%. Anything lower, they say it's low grade. Okay, good. It's probably low. What else is in there? That's 37% of iron. It's an iron ore shipment. It's not a nickel shipment. Okay. One shipment is probably not economical because you cannot put one shipment of 50,000 tons, wet metric ton, into a refinery. The cost of running a refinery is low. But 3 shipments is enough. If you stockpile them to run it, you make extra money. This is like, I'm sitting here as a foreigner, I'm looking at it and I said, no guys, we have to fix this thing. So I've written the new regulations for bauxite pricing. That's already with the drafter, legal drafter. We'll be sending it back and forth. I'm doing it for nickel with associated minerals. I want to do it for gold and copper as well before I go. My contract is up next month, but on November, but hopefully they extend it. So those are
Make
things.
sure they extend.
I can't decide. So fiscal regime reforms, very, very important. Okay, the other thing is alluvial mining license. The entire Guadalcanal, the plains is full of alluvial gold. People are panicking. Why are we giving prospecting license? What are they going to find? Prospecting is supposed to be for hard rock. They go and look for it up in the mountains. Down there, people saw the gold already. They're panicking. Why are we tying our legs and hands, putting a law that if you want to apply for a mining lease, you have to get a prospecting license first? Who said that? Why can't you just apply for an alluvial mining lease, restricted for Solomon Islanders, or like what PNG is doing? Mm-hmm. And they can coexist with a PL, which is held by someone else. So people, the PL holder, which is a foreigner, can be able to look for hard rock at the source, and people down here can get alluvial mining license and do mechanized mining down here.
For the landowners.
Landowners, it's for landowners. Landowners, alluvial mining license is restricted to landowners. In PNG, it's the same. If a company wants to come in, they look at the beneficial ownership. Who owns what? It's got to be a 51-49, at least. The majority goes to the landowner. That the leaseholder is always a local. If the partner is not happy, he can go. Someone else can come under a commercial arrangement. The leaseholder is still the local guy. Goes down to CBSI. Why are we giving export license to all this Tom, Dick, and Harry? So that's our law. Gold dealers license we were talking about. Okay, it's good. It's an SME. Okay, so go and I'll give you a gold dealer's license. You go and look for gold, but sell it to CBSI. Why are you giving it to someone else to export it? So my proposal here is stop all export, cancel every export licenses for gold. CBSI keeps the gold, buys all the gold at a regulated price, and gazette it every now and then at a determined time, and then everybody sells their gold to it.
Have you had a look at the pricing? So the export of gold or even export of nickel or bauxite,
Yep.
the price of those shipments, have they correlated with international market prices?
Okay, so thank you for asking that. That's a very good question. I've done the pricing for, when I did the royalty calculations for bauxite. You have to look at the price of the end product, what's sold out there, like the London Metal Exchange or the Shanghai Metal Exchange. Those are the important. This raw product eventually will become saleable at that price out there. So working from there, what I did was I took that price and worked backwards. You don't have a projector here, I can show you the calculations.
But please give us prints.
Okay,
Yeah.
I will, but it's a little bit complex. But the methodology is you get the price of for bauxite is alumina. Okay, nickel is nickel. Okay, but nickel going in as a raw product, it's got iron, chromite, it's got cobalt, it's got magnesium, silica, it's got all sorts of stuff in there. Most of them are very valuable, but they go out as nickel. Out of that, after going through the entire refining and the smelting process, they end up becoming the nickel that is sellable. For bauxite, it becomes the alumina, which eventually becomes aluminium. Those prices are regulated prices. They're world prices. They're fixed. They change all the time, but this is the price that is like a benchmark price. We use that, and then what I did was I back calculate all the way back, looking at the benchmark prices of the refining, smelting, average of every country down, look at the average shipping cost, look at the average transportation cost, handling cost, whatever, all the way backwards until I come down to the FOB price that we apply here. Now, there's a problem to that. FOB, free on board pricing, is mostly for gold because it's a near finished product. Gold-rich do the gold Doriba, which is like, it's just one step away from being refined to a 99.99% pure gold bar. The Doriba, they have to refine it. So 3% royalty is fine. PNG's got 2%. You got a little bit higher, and I still think it's too low. But after mining, after gold reach, they mine all the oxides down. It's la red plug around here, brown player, M oxide. Earlier on, the big other companies were mining. Now they're going to the gray stuff. The gray stuff is called the sulfides. The brown stuff, they mine it, they crush it. Sorry, I'm going to explain a little bit so you understand. The brown stuff, which is called oxides, the gold is easily liberated. It's easy to take out. So what they do, they crush it, they put it into the heap leach. Down there, they dig a hole, and they line it up with plastic, and then they run series of pipes down to the bottom, and then extraction points down there. And then they put all this ore crushed, they put it up, and then they irrigate it. Or put in spray on top, now spray cyanide to go down. Now, what the cyanide does is it leaches the gold through as it flows down, it leaches, attracts the gold. As a man, America, I attract him, not took a long time, I'll bone, I'll go down. I'll go down the bottom of the pond. And then once in a while, they just pump the liquid out, which is called a pregnant solution. They pump it out into tanks, and then they go to a carbon in leach tank, and then add carbon, and then they just strip the gold. Okay, and then they go and then all go smelting. They were doing that up until lately, last year or so. They've gone past the brown stuff, now going to the gray stuff. They can't do the same thing because the gold is locked up inside what they call silicates. So now they're employing a different tactic. Now they run it through the flotation. That's the only way to liberate the gold. But they cannot go any further. They have to ship that concentrate so that offshore, so that they can be able to get the gold out. Now the question is, 3% of gold bar, why are they applying 3% to the concentrate? It should be higher. Should be around
so how much
7 or 8.
gold would be in the concentrate?
Well, if you look at the sulfides got higher grade, the oxides got low grade. Now, if you look at that, the grade of the concentrate, it'll be higher. There'll be more gold in the concentrate than from the oxide. Oxide, because you've already mined down, Oxide is about, I'm close to finish now. They're going now, the expansion now they're talking about, they're going deeper, it's going to the sulfides. We need to be ready to fix our,
So do we then get, so when they send the concentrate, do we then get disclosures of how much gold was extracted from the concentrate? Of course, we don't have control at that point.
that comes to the point of, does the government have a geochemical laboratory? Very important.
But is there an average, like in New Guinea?
No, you can't go on average. The gold grades, they change all the time. It's all about the grades of the gold. How much gold metal is in a ton of rock. In a concentrate, the gold grades is probably a bit higher, like 32 grams or something. But also don't forget, there's silver in there. Gold is married to silver. They always come together. They don't separate. You only separate them when you refine them. We're not getting value out of the silver that's contained in there as well, because it goes out on. The biggest issue we have here is if a geologist or a chemist, like what they did in PNG, they do the same process. They pipe the concentrate down to Kiunga, from Tabubil to Kiunga, and there's a port up the river. They dry it, they sample it, they assay it. Government geologists and chemists are there. The company chemist is there. They all take the same sample, split it. You test it, I test it. We all agree to a certain level of error. Good, fine. Okay, send it. It goes. Why are we not doing? This is the main thing that brings money into the country. Why do we have to believe a bunch of company people with all sorts of backgrounds who, you mean Sao Lol? Now they give us a little piece of paper and say, this is the essay from what we shipped. I won't believe it. Because I haven't done an independent verification, so I won't believe what you tell me. They give it to us. Why can't we do the same here for ourselves? So one of the things in the mining master plan, number one is the government must set up, through donor funding or something, must set up National Geochemical Laboratory. So that every shipment that goes out, we do the assay ourselves. They do it, they give the results. We do our own with the results. We compare it, good, go. We're not doing it. And big plus something straight. You know, harem toto blole. Although the nickel is low grade, it's 1.5. Who said 1.5? I haven't checked it. Why should I believe you? So you mean him? That's the type of thing I'm saying. Solomon Islands, Solomon Minerals Holdings. Who's stopping us from creating it? This company can go and partner with the landowners or the provincial government and go and mine the bauxite in Renal. It's just a truck and excavator operation. There's no big capex in there. There's no big capital outlay, unless you want to build a copper mine and then do the underground works and then put a smelter up here. Then, okay, you need $400 to do it. That company can do it. But really something on nickel, no, it's less something. We can do it. And that's why we say that clause in the law has to go. And you need to create something like what the PNG is doing for the oil and gas and mining. We have to do it because in that way, you'll sit on the board of that operation, you will decide as well. You have a voice on that board. Right now, we don't have a voice on, even if they have a board or not, we don't even know. It's probably a one-man show. How they do this, how they want to. The danger with this type of thing is, in the absence of ring fencing laws, they can take money from this operation and go and start a new operation here. You mean him? Landowners and people from here get nothing because the money here, they erode the basin and take it away to somewhere else and start up a new thing, like what the logging companies do. It's very endemic in PNG. We don't have ring fencing laws. That's one of the amendments that are put there is we need to put ring fencing laws so that it stops company from eroding the base of how much they make from one particular area, shifting it offshore to another country or elsewhere to start up using money from here. And when you are an equity holder and you look at the profit, there's nothing there because all the money goes out to. So ring fencing law must be in place. That's one of the amendments proposed. Grandfathering laws, beneficial ownership. Like if you talk, one company goes bust, it's difficult. It voluntarily liquidates, disappear into thin air, and then comes back as a different person. We have laws around to crucify this type of people. Look at who the directors are. You same. You are that guy who used to be there. You are now there. I can crucify you too because you didn't do well on that side. There's tax liabilities. You've done a lot of things wrong. You think you're immune, so you want to come and do this. Do we have those type of laws in place? You mean no got him. You mean need law doing this law. So Solomon Minerals, I want, my own opinion, and I strongly believe we need to take that clause out to government not involved, and then we have to put that in because we need to partake. Some of those things we need to do it ourselves. We don't need somebody else. They don't have money. I'm actually assessing a lot of these technical, the feasibility studies and discovery reports and all the applications for mining, prospecting, and all the applications that goes to the board. I'm actually doing all the appraisals myself. Normally used to go to offshore, like Australia or somewhere, some company down there, but now I've been doing it for the last year, I'm doing it here. I've seen these companies, they don't have money. They come here, they get a license as a security or a guarantee, and they go and raise funds elsewhere. But the laws are very strict. There's a technical and financial capability before you go up to the board. So I won't talk about what has gone in the past, but the way forward now is, some of those things we can do it ourselves. A few trucks, a few excavators. Dig him, go to Malo, lay him down, organize him, buy it out, come, send him scale money. Why are we letting someone else to do it? They don't have money. Why are we allowing them to do it? You mean him? Some strategic license reform are proposing. Like, when the new bill is in, we're going to open the floodgates. Big companies want to go. Newmont, Barrick, Glencore, who's now over in Colosaria. I'll talk about them afterwards. I've got privileges here, so I'll talk about anything, just for you. And we open the floodgates, but law blame me. Some lawyer, I'm not allow him. It does not provide an avenue for them. Like, look at the prospecting license. We said the limit is 7 years. Which big company wants to come and invest in gold and copper when we set the limit to 7 years? Even 10 years is nothing. It's probably good for the oxide or bauxite or nickel because they're on the surface. You're going to do a lot of just aeromagnetic survey and then do a little bit of organ drilling, and then you find out exactly what's there. Within that 7-year period, if you cannot develop a mine, then that's fine. I'm happy with that. Gold and copper, they're in the ground underneath there. In fact, some of the deposits here, they're even bigger than Octedi and Bougainville combined.
Really?
I have to tell you, on this island itself. Talk about the Betty Longa, you talk about Poha, you talk about Hidden. It's a Kolola.
You must extend your contract.
Masse, on Faroe Island. Hey. And Tirua, for instance. Tirua is massive.
Tirua, where?
It's about 3 or 4 times bigger than Lihir.
Where is Tirua?
Tirua is in New Georgia, Western Province. Massive. It's massive. It's in an old volcano. It's called a caldera. The gold there is, I've seen some, Newmont did some drilling there before. The gold is running at something like 150 grams per ton.
So
Australia is mining 0.2 grams per ton as a profit. We're talking about rocket fuel,
So in New Guinea, for gold, copper, silver, prospecting licenses are not time limited?
Okay, they're not time limited.
Ah.
So,
So perhaps the regime should be for some, like bauxite,
yeah, bauxite and nickel, I'm fine, because all stuff will surface here.
rather than one rule for all.
One rule for all. It shouldn't be one rule for all.
Right, right.
Places like Oktedi, it was discovered in the 1960s and developed in the 90s. There's a period of, and then they've been changing hands from hands to hands, and all this time they were building information, they did feasibility, they do all this drilling, until they found out that, oh, okay, now we have something to mine. Bougainville was the same. Lihir was the same, discovered back in the 1960s, only developed in 1997. These are examples I'm giving you because if we open this up, nobody's going to come. No big player will come here. I'm talking from experience, and I'm talking from talking to other people. They know, I've got a network, and talking to other people, I said, we don't like that law, because what's the guarantee to our security, investment? And if you're getting this type of thing, it must have a problem, yeah. We need to address him. We will always attract people who come here and want to take bauxite and what, but the big players, Solomon Islands is a hot spot. It's a melting pot. You take it from me. It's a melting pot. It's on the same zone that goes up to Bougainville and go to Lihir and cuts across that way to Porgera and to Grasbeck. It's the same structure along the same zone. Biggest deposits are here. This law is stopping us.
We must create a new constituency. These guys should be in power.
Okay, number 3 is comparative snapshots.
So I waited back home.
PNG versus Solomon Islands. I'll look at what those things I'm talking about, what we are doing, and what PNG is doing. And if we can look at creating a hybrid model, hybrid, probably complete change may not be that, but hybrid. I use an example here, number 4, like projected revenue impact. Like, what if all the alluvial gold and gold from equity, like the government, Solomon Minerals Holdings, buys 10 or 20% of gold rigs, for instance, and that gold plus all the alluvial gold is bought by CBSI, cancel all export licenses, gold dealers license, no problem, people can have it. It's part of stimulating the economy. They buy and sell and they're happy. We can't put stop to gold dealers. Where they get the gold from, to me, I'm not worried. They dive under the sea down at the IBS and get gold down there, or they go up to gold rigs. It's a fundamental issue about how you protect and run your operation. You can't cry that the people are mining there, because our laws are stopping them from doing mechanized mining down the. We're giving the PL to somebody. They want to come in and do mining, and so we're creating our own problem out there because of our very own law. We have to give autonomy to our landowners so they can go into alluvial mining, mechanized, and they can coexist with all these other people who are prospecting for hard rock. Nobody's going to have a problem. So I'm looking at that, and then projected revenue. If we get 600 kilos of gold from alluvial operations, that's a projected number from CBSI. And then I'll just look at just generically look at what type of money we're looking at for the benefit of the public. So I do that, and then I'll just put a little bit of implementation timeline. How long will it take? So, sorry, I'm talking a bit, but I think it's my opportunity, so me talk that's all.
Good plan.
First something, me, like Mandemia, long MM, I said revised minerals bill, strategic reforms for sovereign wealth, equity, and institutional integrity. Okay, so fiscal, I've said the alluvial mining license, I've said all that already. So I just want to run you quickly to something something here, legislative institutional reform. I've actually written all this out, so if anything, I'll just pass it on to you, committee later, so you can have it. Like creating a new license category in amongst that. Alluvial mining license. The purpose is to reserve alluvial mining rights exclusively for Solomon Islands citizens, mirroring PNG's approach under the Mining Act of 1992, just mirroring PNG's. Integration into the bill is to define AML as a separate category with simplified application, low fees, and capped production shareholders. Include clauses mandating local ownership with penalties for proxy foreign control. And require registration with CBSI and merit for traceability and compliance. That's it. Everybody is, you're going to put money in their pockets. I'm really blessed here. PNG is over 10 million and 800 different languages, and most of them don't have problems with tenements. You may not plenty too much. This land, plenty something. Number 2 is establish a state-owned enterprise, Solomon Minerals Holding, to model PNG Minerals Holding Limited. Function is hold and manage government equity in mining projects. Act as a commercial arm for strategic investments, joint venture negotiations, and dividend collection. Legislative tailoring is insert enabling clauses in the bill for SME corporation governance reporting, and mandate SMEs to participate in large-scale mining projects with 20 to 30% carried interest. I'll give that.
So some of the mining companies, when we asked about, what, of course, this bill goes the other way, no government involvement, we're going to recommend against it. In fact, we're going to recommend that the bill be withdrawn in its entirety, so you rework it.
Yeah.
So we hope a lot of those points will go in. But,
Yeah.
but when we asked the mining companies that were here, what if the government took up equity stake up to 35% equity stake? The companies were very, of course, very ambivalent. They said that would limit what they could do. It would make it marginal. But is that true, or that's just scaremongering?
That's false. True, maybe in a little sense, but it's false because a lot of, like for me, a lot of the advanced exploration projects, prospecting projects, like the Tiroa, like Betty Longa, and look at the Hidden Valley, Poha, Kolola, all these big projects, Mase, big companies, they surrender the licenses, they go, and a new company is coming in. So if you want to take equity in a project, you can take it almost, because it's like free ground now. You can actually apply for that license and take 100%. Whoever wants to come in, okay, give them 10% or 20%. You can partner. The thing about PNG is companies hold these licenses for long. They've done a lot of work. They put a lot of dollars in there. So what they're saying is, if you want to become a 10 or 20% shareholder, you come in, you pay the percentage of the sunk cost.
Mm-hmm.
So if I've spent, and now we're trying to change it into a percentage of the development cost, sunk cost, whether you're taking your own risk there.
Mm-hmm.
Nobody told you to come. You want to come and spend your money to look for it.
Mm-hmm.
And you found something, fair enough, you found it, but you can't say, I've spent over 20 or 100 million to actually come this far. So if you want to be a 20% shareholder, pay 20 million. Hang on. Okay, that's probably enough, but that's a different story. Like some of these big deposits here, in Miss our stuff, companies have left, they've got all the reports and everything is there. We know it. But you want company coming now, and you want to say, I can't give you equity. So who are you? You haven't spent anything there. These minerals belong to us. We can get 20% of this.
But I mean, could we, in the legislation itself, could we say for all mining assets, mining tenements, that the government would have an equity by law, operation of law?
They have the right to take up equity if Treasury or Finance looks at the numbers
So on a commercial basis?
on a commercial basis.
So not by operation of law, by default operation of law?
You can do it because right now you said the minerals belong to the state and the people. So under that context, you can be able to claim it.
So their argument for commercial viability, because going through this, my gut feel is we are generally incompetent. When looking at this industry, we don't have very good experience with it. And so we have seemed to have swallowed a lot of what the companies have been telling us over the years. And when we're crafting the law, we're crafting it under that basis, where we don't want to scare them away, therefore limiting ourselves.
I'll give an analogy. Somebody wants to come here and build put up a building or a shop. But that shop was bought by that guy. He wants to expand it. That shop was bought by someone else. He bought it from someone else. So he actually spent money up ahead. And he bought that shop. He wants to upgrade it. I want to become a partner. He has a right to say, I bought it for that much. So if you want to be a partner or equity partner of this shop, then you have to pay half of what, a percentage of what I paid for. It makes sense. You can't just come and say, I want half of it. That makes sense. But if someone wants to build a new shop and you want to be a partner, he shouldn't stop you. He shouldn't demand anything. There's nothing there.
But
That's the same thing.
But the limitation of that analogy is, of course, with the minerals, it belongs to the people and the state.
Yeah.
And therefore, there is a sovereign element to it
Yes.
that with a shop doesn't exist. So would you say the sovereign element is worth 30% equity stake with no money being put in?
Well, you
In all
own
gold that you find, we own 30% of it.
You own it.
Yeah,
You own. How can you pay for something you own already?
correct.
How can you pay for something you own already?
So is that,
The Constitution and the law says you own it. So
but PNG doesn't do that.
PNG doesn't do that.
If it did, would the companies
They
leave?
didn't do that. It's attracting a lot of debates. That's why the mining bill is still sitting there, because of people affiliated with all sorts of. You also have to. There's a industry lobby group called the PNG Mines and Chambers, Chamber of Mines and Petroleum. They call it. Now they call it PNG Core. That's a very powerful lobby group that is made up of all the industry people, and they were given a chance to review the bill. And when you have politicians sitting in parliament, and these, wealthy company people, they pull you aside and say, don't support that. Do you think this bill will get passed?
Yeah,
Because they look at a change in a little number. But it's good for the country. But the people who are going to vote for it are not voting for it because someone else is looking after them on the side.
yeah, we've had this problem with logging
So-
for many years.
So this is the thing.
Does any jurisdiction do this? Like a value placed on the sovereign ownership
Oh, yeah.
of the minerals?
You have communist countries.
Well, communists.
Communist, you have got these countries where someone signs a decree. I think this is good for the country. Sign it, people follow it. You don't have to go to parliament like a democracy. And everybody starts voting and all this. I think it's a waste of time. But if something is good for the country,
Well,
it should always.
we're still a democracy. We don't quite.
Oh,
want to
no,
go down
I'm
that
just
line.
saying. I'm not saying, but you see where I'm coming from. So they call it back-in rights. You can put it. That's why they didn't put it into the act. They have it as a policy, and it's been going on for a while. It's, how do I put it? It's a policy that was seen as an act, but it's never in the law that the government can take their back-in rights for mining and petroleum projects, and that's been going on for a long time. I mean, you can put it into the regulations or the policies, whichever way is appropriate.
Could the World Bank assist us in giving us some financial analysis to see what would make a mining asset here feasible, viable financially.
Okay, so-
and therefore, to what threshold can government take up equity without causing the company to abandon operations?
Okay, so part of my job as I'm a strategic mine planner, I used to do mine modeling and do a lot of the financial models for mines as a job in my past jobs. What we do is we look at the discovery and we do a feasibility study, and then we do a financial model. We do a cash flow analysis. And through the cash flow analysis, you come up with, this net present value of the project. And then you look at the internal rate of return, which is equivalent to the interest rate in the bank when you deposit money or just keep them in the bank. These are very critical numbers. And then you have the hurdle rates that I think, we call it the discount rate, the hurdle rate, which, so those determine, the Ministry of Finance determines that particular project's got a very good internal rate of return. I think we should take equity.
See, I think that kind of capability we don't have. We have capacity problems, so we don't understand the sector at all, I think. The bill, in any case, betrays that lack of capacity to understand it. So, for example, we look at Gold Ridge. The ministry has no idea what the break-even price is for Gold Ridge.
Yeah.
So then, so if we don't know what that is, well, we don't know at what point they become profitable. And then the issue of a windfall. So now the price is almost $4,000 per ounce. Well, there is a huge windfall there. Well, how do we calculate, what do we get out of the windfall?
Yeah. Well, if you look at it, there's something called a cutoff grade, which below which you don't make money, above which you make money. It's the line, but it mostly depends on the cost, the price. These are the two most sensitive. The price of gold and your costs. Those determine the gold grade, below which you treat it as waste, above which you mine it. It's called the cutoff grade, very critical in mining projects. Now, we really don't have an idea of what the cutoff grade is here because the ministry has to tell them. So I've been telling them that every mining project now, they will have to put in a financial model and a life of mine plan to actually tell us whether this project will make money or not. And if it does, by how much? Because that's a number where the government can plug it into their budgets and do the forecast and all this, without which they have no idea. So I'm putting that into the new format, the new pro forma that is now being currently used. We're rolling it out in the ministry now is for every mining application, they must have this financial model and the cash flow analysis and the life of mine plan. They must, when they get an LOI, they're going to do it within that period. If they don't do it, no license. Why do you want to give a license when you don't know how much money they're going to make? Why are you giving nothing license?
And I mean, so the question is, say with nickel, for example, the nickel price crashed a few years ago, and it's only now, I think, slightly recovering, but not by very much. So from a sovereign point of view, when the price goes below what we would get for, the country would get for the mineral, we must have our own comfort level. We must say, you have to stop shipments. You can't continue to mine, because if you're selling at a very low price, you may stay afloat as a company, but the country gets very, very little. The 3% is 3% of 100 instead of 3% of 10,000.
Yeah.
But we don't have that data, and so therefore we've got all these DSOs going out at a very low price. It's just ridiculous. It's crazy.
It gets more attractive when the government actually runs it. Most mines in India, they're owned by government and they're running at break-even. Surely, just purely to, put money in people's pockets and just they're not really worried about the profits. Just like they earn, they spend, they're running at break-even. Most of them do, but a lot of mining companies, like They come in here just to make money. But just imagine, if you are the government, you're an equity partner there, this company said, I can run it. Okay, go. I'm going to run it. You can change things in there so that you can at least run it. Because they have big overheads, we don't have it, most times. Just the type of scenario. So we need to be flexible and have clauses within the law that give us the leverage to make decisions, even when we have to. Situation change. Okay, so, like for example, 10 years ago in Australia, when the iron ore price was up, going off the roof, when the industrial, the Chinese, demand for steel was very high up there, iron ore price shoot up. So the then Prime Minister, Julia Gillard, introduced what they call a super profits tax and said, anything above this level that you make extra due to price increase or whatever, the government will get 50% of it. Your cash flow analysis, you said that you'll get 33% is, 33% is higher than 20%. You've got this margin of profit already. Now the gold price or this commodity price has gone off the roof. Not that anybody's doing it, it's natural or something. So why should you take all the windfall? One half of it. Oh, every company was jumping up and down, but eventually they said, okay, fair enough, because you didn't spend extra to make that extra. It's because the price of the commodity went up. So why should you enjoy the whole, take the windfall away and I'm going to be the owner, I'm sitting here looking at you. That thing happened. And that can happen. And I've written something on that particular type of, like the super profits. When you look at it, you can put clauses in there, but I'm against putting hardcore coding numbers into any legislations or regulations, because you need to do it like they call it the ad valorem, where you put a formula and base it on production or base it on something. So if it goes up, you get up. If it comes down like that. And the royalty, I want to make sure that it's around that type of thing. Price goes up, royalty goes up. Everything else goes up. It's all linked to production, price, and all this kind of thing. So I've done it for nickel, bauxite, which is going to be rolled out as soon as it's gone through. So, okay, I'll just go through here. Create an independent regulatory agency. Very, very important. Solomon Islands Mineral Resources Authority, or whatever they want to call it, they have to get the policy functions of the ministry away from the regulatory functions. Separate it. PNG used to have the mining department ever since. In 2003, they found out that this thing is not working because there's conflict of interest. You do the policies, and you can't even go, the same people, you can go and police it. Your enforcement is weak because you are the same people. You help people to get licenses and all that. How can you go and crucify them if they make anything wrong? So they split it, and they created the Mineral Resources Authority, a completely autonomous regulatory body, agency, got no funding from government. They make their own funding from production levies from mines, license fees and everything else. They make it their self-funding. They do their own recruitment, they do their own things. Okay, separate from the policy functions of the mining ministry.
So they issue licenses? No.
They issue licenses, and they do the inspections, and they do all the recordings of production, everything. Licenses, cancellations, Mineral Resource Authority does, not even the ministry does it.
So there's no, like here, Minerals Board, no need?
No, Minerals Board.
It goes to the MRA?
It goes to the MRA. The MRA goes through all the licenses, and all the members in there are ex-officio members, or they are other delegates from various government departments. They come there. A minister has his rep on the board, but he's got no direct control over the board decision. And the board's decision is final.
And by and large, that experience has been good?
Oh, good. It's been going since 2005.
No corruption, mining companies trying to
Well-
infiltrate?
How can you do it?
No?
Like, how can you do it when the MRA is funding itself? They come to your site, they don't notify you. They just come on site and to catch you by surprise, because they can do it themselves. The license process is so, strict.
Well, maybe New Guinea is not as corrupt as we are, but that sounds really good.
They got Jesus in their heart.
Corruption or there's also the definitions about corruption. Okay, I'll give you just some. Place like Wafi Golpu, they put in the mining list application. They haven't got it. 10 years down the line, they're still waiting. Because the process is so stringent. The minister's got no authority over anything. The minerals, the Mining Advisory Council, they call it, which is the Minerals Board, is a totally different entity.
On policy only.
Yeah, and the policy people are from the Ministry of what they call. The word mining is not even in there. They call it mineral hazards and geopolicy, geohazards and mineral policy. They call it mining policy. Totally different. I've never seen them when I was working down there.
Right. So you deal with the MRA only.
I was doing the MRA strictly licensing. They've got this FlexiCadastra system operational. If you have a screen here, put it on. You see all the licenses are shown. Who owns it, by how much, what type of commodity, and it is overlain over all the boundaries in the province, everything. The map is so clear, and you can do all your payments online, you can do all this, everything is online. There's no way somebody can go in there and put something in there.
So I wonder, we asked the ministry when they came why there is no MRA in this framework. I wonder why,
I've got that in the mining master plan, which is generally a broad roadmap for the next 20 to 30 years. How
all the minerals will be stolen by then.
No,
It's great in the master
it's a
plan.
plan. You can start doing it tomorrow.
We need it in the legislation.
Legislation, someone wrote it. That person can come back and change it. We'll all sit here and tell him, write this, write that, and we can do it. It's not written by God, It's written by someone. We're vetting it, we're going through it to see whether it makes sense. That's why we're here. If it doesn't make sense, why do we have to entertain it? There are fundamental things that are missing. That's why I'm so sorry to keep hold on to your time. Technical and licensing oversight. There's the Solomon Islands Mineral Resource Authority, and then there's one I call Solomon Islands Environmental Protection Authority, separate from the Ministry of Environment, purely for licensing and compliance and monitoring and enforcement of environment. So what happens down in what the MRA, the process is, say this application comes in, somebody who wants to get a prospecting license, we call it the exploration license, gives 3 copies, goes there, and we don't apply online. If you want to do business in PNG, come, let's talk. Come to Moresby. It's dangerous, but if you want to do business, then come. We don't let people, the process here is on the MCAS system. Somebody can sit comfortably in Melbourne or Sydney and then apply. And someone else goes up here and find out that that area is taken by somebody who's somewhere in Toronto or someplace. It's unfair, right? Why can you sit out there? Why can't you come here? So application process in the MRA is you make 3 copies, the forms are there, everything, 3 copies, you go there, you sit with the tenement registrar. It goes like this. Okay, sit there, don't go. Oh, no, this one is not right, take it back. It goes back, comes back. It looks good, it goes on the system. Not like someone out there putting something onto the system which you haven't checked. Okay. When it goes into the system, what's done here is a little bit funny. No, my bosses are not here, but someone has an application form. He goes to finance, pay him 10,000 or whatever amount. Only go up to the ministry and to find out that the area he's proposing is overlapping onto someone else, and they reject it. How will he get this 10,000 back from finance? It's like asking go to buy you breakfast. It won't happen after a long time. So that's the beauty of people going in there with physical papers. You sit down, we talk, and you say that you are actually dealing with a human being. If you want to, if you go into minerals, come na imi totoga. You man, me man too, imi totok na. Okay, so this is not happening. Second, the 3 applications. One goes to the ministry, tenement registrar. He put it on the Flexi system or the online system. One goes to the technical assessment branch, which the geologists and the engineers look at the technical side of this, whether it's competent or not. This copy goes to the mining warden. And the mining warden looks at this and everything, and then he will schedule a warden's hearing in this particular area where the area is located. Some of them covering Tupla province. I'm scheduling warden's hearing. That's the very first HEP-PIC process. Free, informed prior consent from the landowners. They set up a schedule, they advertise it on the papers, on the news, get the provincial government, lands board, lands department, everybody involved, administration, the company, and MRA. They all go to this particular area at the nominated time. All the landowners there, companies here, the warden introduced the company and said, this person is interested in trying to explore for so-and-so minerals in this area. Who has an objection? Everybody said, no, we're happy. That this particular meeting is recorded by the warden. So if anyone has any, you got 30 days to object to this company. That's the very first. It's right in the beginning. Not even, this paperwork hasn't gone through the system of anything. It's just the application. Now, when it comes in, the technical report and the warden's report forms this document that goes to the board. When the technical report is okay, but the warden's report said that landowners are not happy, this application is thrown away. It doesn't even go to the board.
So one of our problems here is the surface access agreement.
Surface access agreement.
So the mining company goes first to the landowners on its own.
No.
They bribe and they do all sorts of things.
Surface access agreement is only done after an LOI is given by the minister, after the board's approval. The board approves it first, and then they give them a letter of intent, which the company gets the letter of intent and then tries to go and negotiate the surface access agreement with the landowners. Now, what's getting more complicated is when a mining lease application is applied for. Okay, when a mining lease is applied for, the same mining lease you apply for, one of the copies is going to the Environment Conservation Authority. They look at this application, they do their own thing, they go and get their own studies, they get their own consultants to go and review that area. These 2 applications, the wardens plus the technical assessment report for the mining lease application does not go to the board until you get an environment permit for this application. These can sit there for years. These guys can take how long they want. As soon as, because when it goes to the board or the council, if it's a mining lease application, they're going to start looking for the environment permit, what you can do and what you can't do. And the person sitting right there in front is the director of environment. If he doesn't see this, however good it is, it goes to the bin.
The other issue we have with current legislation, which this bill has inherited, is the first come, first served rule. How's that done in PNG?
First come, first served rule is the same in PNG. But now they're trying to do an amendment to say that it's on a case-by-case basis. If it's an advanced project, kind of some big companies have come and done this, and it's a known deposit. Why first come, first served? Now you might give them one company just come
Correct.
from nowhere. Now you give them this, and I'm not on grassroots. When you can be able to elevate this project higher by tendering it and putting it on tender, and then companies with capability and money can come in and then they bid for it and they can get it and take it from that level higher. It's already up here and we're going back down here. It's going like it's like a spring. We're going back and forth. We're not taking it from there up. The only way is we have to tender it.
So would you recommend, that's one of the practice so far? First come, first served rule has really encouraged the speculators more.
Yeah.
So if they hear of something that a big company might be interested in, of course they on the ground, they go and put in an application. So then they get the license and speculate on the basis of it. But if we remove that totally, would it prejudice?
No, it won't. It won't. It's going to do us good. And it can only be done the separation has to happen. The Mineral Resource Authority has got no interference with politicians or anybody from outside. They can be able to say, okay, put all the list of projects, currently explorers and prospects, and said first, second, third, fourth, down in the magnitude of, importance or whatever, however they want to do it, and then said, these projects, these areas, any application that comes in, will be tendering those. Because we have enough information that we can put this out in tender documents of those projects. It's not a greenfield, it's a brownfield. Big companies are interested in there. You tender it, they'll apply for it. But then goes back to the term of the license I was talking about before. They're all interconnected. If you still have it, if you still have it at the current format that we have, even if we do that, even if we tender it, nobody will come because they know the term is only 7 years.
Yeah, so the current one, prospecting, is 7 years, yeah, and mining is only 25 years. Is that unreasonable, 25 years?
It's not calculated, it's not thought out properly.
It's an arbitrary figure.
Why do you want to set a limit for something that people are trying to find?
Yeah, I mean, it should be the life of the viability of the mine.
Yeah, well, you want to find something. There's no guarantee that you'll find it tomorrow. Why will you tell them and say, oh, you have until Friday to find it or else get out? What if he doesn't find it? He wants to find it, but you have set him a deadline, so he has to go.
True one.
So, okay, you find him. And then in the process, you just tell us what type of work you are doing and how you are progressing. If you feel that you want to go, okay, surrender it. But if you feel that you're doing more work and you know it's there, you're getting closer, why should I set a deadline and say you go? And someone else comes and starts from zero. There's no rationale in setting this. Maybe it's good for nickel and bauxite or something. Limestone. Get some sample and test it. If it's okay, just go and mine it, blast it, and process it. Copper is different. It's deep underground. Nobody sees it. Only God knows how much is in there. You mean him?
So that's low prospecting, but Sadlo mining, 25 years? They've got 25 years.
No,
Yeah.
it cannot be 25 years. Mining in PNG, now for mining lease application, alluvial mining lease is 5 years. Okay. Mining lease is for 10 years, renewable. And currently, I think PNG have a mining lease and a special mining lease. They have another category called a special mining lease. Special mining lease is you go over a certain threshold above which you can be classified as a special mining lease, and that is only approved by the Governor General and by Cabinet. The mining lease is only approved by the Minister. So if we say a big copper mine here, it cannot be approved by the Minister, it goes to Cabinet. And then it's signed off by the Governor General. So they have this special mining lease. So you see Pogra, Wafi, Lihir, Oktedi, these are all special mining leases because of the magnitude of the project and the importance of it.
Right.
It's not one man's decision.
Yeah, man. True, yeah.
They do that. So, I'm not saying me look at Muslim. So, as you strictly go and fix them all this law. We need to create another license category for a special mining list because it will attract a full EIA, environment impact assessment. Because of the damage and the magnitude of this is big. Second thing, where are you going to dump your waste rocks? You mean you're going to dig this mountain out. You need to throw this waste rock somewhere. You can build an artificial island somewhere in the middle of the sea, but that's what Lihir is doing. They call it subaqueous dumping. There's an upside to it because it's underwater. It's not exposed to oxygen, and so it doesn't deteriorate, give out this sulfur and all this water. It's a good thing too. So it's a big plus. Someone has to think about all these things. You cannot just, someone wants to do Gold Reach is now, the expansion now, where are they going to throw the waste rock? Down to Rarana. There are people down there. I haven't seen an engineered waste dump yet, so I haven't even looked at the whole proposal. It's sitting in my house. You know, and capacity, unfortunately, committee, I have to tell you, capacity, we don't have it here. If you look at it, the people, you should have your own Solomon Islanders doing this type of stuff that I'm doing. I want to train people, but there's nobody. Who know about me training? You mean him? All the geologists and engineers here, they're trained in PNG. Our PS is a geology grade from UPNG. You know, everybody, inspectors, everybody up there. All graduate Unitec Lolea. So MB plus strategic something is supposed to government serious. Upgrade him Sinu, put him faculty plus engineering, environmental science, geology. So we're trying to do this bilateral, we're trying to do this MOU with the MRA. That's something that's been going up, started it last year. But we're not getting the support. So now I told the PS yesterday, I said, listen, mate, let's do it on a bilateral level. We try to do it on a sectoral level. It's not getting anywhere. Get it on a bilateral level, from government to government, and then from there, put that in. In that way, government, Foreign Affairs Department, it's part of the thing, arrangement now. Then you can work on exchange. Get MRI people to come here, you know, help out the ministry, tell them how to set up the MRA and set up all these things, the licensing process, all this kind of thing. We need to start thinking big now. You know, otherwise the Wakus are going to run rings around us. So those are things that I keep telling the board at certain times. I said, mate, I won't be here forever. I have to start having somebody understanding me. So when I go, you know, someone's contract finish, let me go and listen. I'm not going to walk out, look at this type of thing, because if the bill is okay, so how can we operationalize it? How can, you mean a problem here? So we need to look further ahead, just beyond about what we can do for the mining industry. Okay, I think I'll get some questions from you, gentlemen. Just the fiscal reforms, I was talking about royalty and equity participation. Current gap, lack of clarity on royalty formulas. Nobody has an idea here how the royalty calculation is done. Until I came here, I started doing the formula. I did a presentation to the finance department, the CBSI people, the reform unit, and showed them how you can do this. You can't do FOB. You can't do FOB. It's for finished product, like gold. You have to do something called a net smelter return, which is for raw products or concentrates. And there's an upside to it because there's more you can get out from that. It's a widely accepted practice. So me working formula plus la.
So finance didn't know either.
No ma. So I did a little workshop. I went through, said this is how you do it, this is how you do it. I was supposed to go and then set something up for them, but I can't just go there. They have to ask me to come and do it. You mean it? Okay, looking at royalty rates as a 5 to 10% of gross value. You can't ask for less. You cannot. It's criminal when you ask for less. And if they want to do it, they'll stick around. They'll complain, but they'll stick around. Mandate equity participation, 10 to 20%, carried by Solomon Minerals Holding and local trusts, and carried interest model to avoid upfront costs. So if you don't have money now, that's fine. I'll still be a carried equity. When you make money, you can take it away until I'm fully forgiven, you know. Introduce the tax credit scheme, make it attractive for them as well. Like 1.5% of their accessible income. Instead of we get it, they can use it to build roads and health centers and schools where they're operating. So when it comes for time for paying corporate tax, just take this away from them. Most of them don't even pay it, so what should we worry about? We get them to pay it. It's attractive to them because they won't do it for free. And gold export license cancellation and CBSI gold buying scheme. Very, very simple. Prevent gold smuggling. Improve revenue capture and stabilize the forex reserves so that the Solomon dollar doesn't slide down. Most countries are doing it. Why are we not doing it? You mean him? Why are we allowing any Tom, Dick, and Harry to come and get export license? Why not the central bank? Like, we are the government, we are here, you mean government, this is our land. Stop this. Put a stop to every export of gold. Everybody come sell to CBSI. CBSI stores the gold and sell it whenever they want. Build a refinery, whatever, they can do it. It's done everywhere else. Somebody's telling us we can't do it here.
New Guinea refines
They did
its
it
gold.
before. PNGBC was a government-owned bank, was actually buying gold. You see a line of people on that side, they go and withdraw and deposit and withdraw. There's another line, they will carry gold, on gold line goes Salim Los. It was done before.
But not anymore?
It was done until PNGBC was sold to BSP. Privatized. For some reason, some people had their hand in there. But the new bill, they're talking about a national bullion bank, which is going to be owned by the government. So that's on foot, the new bill. Okay, so it's revoke all private gold export license via transitional provisions, mandate CBSI as sole buyer of alluvial gold and government equity gold. So if government gets 10 or 20% of gold rich, that portion of gold comes into CBSI. And set up a CBSI gold tax with fixed daily rates, traceable protocol, and export control. We won't have gold smuggling issues. We will know what's going on. The price will be probably set and managed, so everybody's going to run to CBSI. We discussed it with CBSI. They're happy, but it has to be formalized and then, put into.
But it seems CBSI also is incompetent in these matters. They don't have the competence to give advice or criticize finance for the pricing issues. I mean, this has been going on for years and years.
I think it was a joke, but when I did a presentation and when I finished, I said, "Oh, when you finish with the World Bank, can you come and help us out?" But I mean, it has to be done.
It has to be done,
It must
yeah.
be done. It must be done. So I think
That's all?
that's all, yeah. Let me talk. Last through me talk. Minerals beneath our soil must no longer be a case of lost opportunity. With the right laws, institutions, fiscal tools, they can become the foundation for a sovereign, prosperous, equitable Solomon Islands. Thank you, committee. I'm done.
Sam kutla, mipla hamamastru. Thank you very much for that very detailed and informative interaction with us. I don't know whether my colleague, leader of the opposition, has any more questions to ask. No, we are happy and grateful indeed for what you have shared. And you have a speaking note there. I think we would love to have it, and maybe you leave it, you work on him more, and then put him come to secretariat.
And the pricing stuff.
Yeah, yeah.
I've actually done this bit of a calculation. So this gives you just an outlook of, we talk about 600 kilos of gold and then the gross value, royalty, equity, and the total public benefit. Those type of things, it's all
Right.
calculated. I've actually put the formulas and
Okay.
just in there. Just feel free to I would really like some of these things, because I'm talking from experience, also as a miner, as a mine planning engineer, as an operator from the company's side, and also working on the other side of the table as the regulator and from the government side, doing my own consulting, and then also in this role as well. I have a broad view of what I'm speaking from is basically from experience and from the issues that I've seen. And we are now in the process of fixing some of those things to make sure that the law that is about to be passed or may get rewritten and go through the process again. Anything for the best. We can be able to just try and tailor it so that it suits us. That's basically the...
Absolutely. So, Sam, thank you too much. Thank you, and again, we look forward to further help in submission to our secretariat, locator notes here, and it will help us certainly for our report and recommendation. Mifala, understand him. Thank you. Good afternoon.
Thank you. Thank you, Chairman. Thank you,
Leader.
Leader, my opposition leader.